Brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, officers, officials, listener learners, professors, professionals, I welcome all. It is really nice time, nice place, nice section today. I welcome respected doctors and directors. I welcome honorable ministers and managers. I welcome honorable advocates, advertisers, administrative advisors, the most honorable President Prime Minister Modi ji. It is really nice time, nice place, nice action. Today we will go through our holy Indian Constitution, our holy Indian culture, its spiritual values, social values, political, economical are really praiseworthy. Nature is the common concept of all our different subjects of study. Nature is the common concept of all our holy religions of this holy land. All spiritual starters, beginners, initiators, creators, generators, operators. What is humanity? Humanity means to share our joys and sorrows with others. It means also to share our food and clothing, shelter, whatsoever we use, that should be shared according to the concept of humanity. Every festival that we celebrate, it has a message behind it. Message of our freedom fighters, free thinkers, delivered for the welfare of humanity. Law and social transformation. How Lok Adalat is constituted. Let's describe its jurisdiction, powers, and procedures. Lok Adalat is an easy and coordinate enterprise or platform of disposal of matters. Lok Adalat is an ancient concept. It is a strong platform to dispose of the matter by traditional way of settlement. It is considered an ancient concept of justice like Panch Parmeshwar. Earlier reputed persons of village by sitting at the mid of villages used to solve the matters by settlement. Gradually, it has transformed into Lok Adalat. At last, at start, Lok Adalat does not have legal reorganization. Later, it was provided legal reorganization by Legal Service Authority. Today, Lok Adalats are very famous and popular. Now, mega Lok Adalats are held in whole country, which dispose of large number of cases. Lok Adalats are generally part of public platform of settlement and conciliation, a source of fast and cheap justice. Constitution, Section 19(2) of Legal Service Authority Act 1987 has provision regarding the constitution of Lok Adalat. According to this, Lok Adalats shall consist service or retired judicial officers and other person. Other person shall be such person who has adequate knowledge and experience in the field of art, culture, literature, law, justice, social service, etc. Women also actively participates in Lok Sabha. Women's Women also actively participate in Lok Adalats. In these social services, social worker, advocate, law professional also provides their special contribution. Jurisdiction, Section 19(5) of the Act describes about the jurisdiction. Lok Adalats can decide all such matters by settlement compromise. One is any case pending before, or two is not brought before any court, such as Lok Adalat has jurisdiction to hear all the matters which are pending before or is not brought before any court. These are known as pre-litigation, conciliation and settlement. But Lok Adalat does not have jurisdiction to hear the matters which are not able to settlement. Generally, those criminal matters comes under it, which are mentioned in section 320 of Criminal Procedure Code 19F73. Lok Adalat can settle those matters which are described under section 320, not others. Ramlal versus State of Jammu and Kashmir, year 1999, SC 895. In this matter, Supreme Court decided that those matters which are not eligible to be solved by settlement in legal way, those cannot be settled by compromise, neither it can be made wrathful to compromise by permission of court. Powers, Section 22 of the Act describes about the powers of Lok Adalat. Lok Adalats are considered as civil courts and it has been provided the same powers which are given to civil courts by the Civil Procedure Code 1908. These are following: to is discovery and production of any document. Three is the reception of evidence on affidavits. Four is requisitioning of any public record. Five is other such powers as may be described. The proceedings of Lok Adalat are considered as judicial proceedings according to section 193, 219, 228 of Indian Penal Code. These are provided as form of civil court. Under section 195 and chapter 26 of Criminal Procedure Code, what is the procedure? Section 20 of this act described about the working process or procedure of Lok Adalat according to that. One is where any part wants to disclose, where any part wants to dispose of his matter to Lok Adalat, then it shall make an application to the court from referring the case to Lok Adalat for settlement. Two is, if the court is prima facie satisfied that the matter is an appropriate one to be taken cognizance by an appropriate one to be taken cognizance of by the Lok Sabha Lok Adalat, or there is hope of settlement between the parties, the that is that shall refer the matter to Lok Adalat. Before sending the case of Lok Adalat, other party shall also be given opportunity of hearing. Where matter has been paid to Lok Adalat, then it shall proceed to dispose to the case or matter, and Lok Adalats are bound to follow the principles of equity, justice, and conscience. Money Mithai versus Federal Bank AIR 2003 Kerala 164. In this matter, Kerala High Court decided that in Lok Adalat, while disposing of the matter, it must follow the principle of equity, justice, and good conscience. Where no compromise or settlement is made between the parties, then the matter shall be returned to court or where it was referred to for where it was referred in Lok Adalat. Both parties are informed about it and it is expected from them to request or to get remedy. National Insurance Company Limited versus Karthik Gorian AIR 2010 Jharkhand 59. In this matter, Jharkhand High Court decided that it is important for Lok Adalat to disposal of case that get the written consent of both parties, follow the procedure mentioned in section 22C1, procedure on settlement, where compromise or settlement is made in any lok adalat, then lok adalat under section 21 shall pass an award, shall have the power of civil court. Both parties to the matter shall be bound by the award. No appeal can be made against such award. Court fees shall be refunded to parties in case of settlement. Punjab National Bank versus Lakshmi Chand Rai AIR 2000 Madhya Pradesh 301. In this matter, Madhya Pradesh High Court decided that according to the provisions of Legal Services Authority Act 1987, the degree of decision of Lok Adalat shall be final and binding on parties as Section 21(2). P.T. Thomas versus Thomas John AIR 2005 SC 5575. In this matter, Supreme Court decided that award of Lok Adalat is an order passed by Lok Adalat under consent of parties. Hence, no appeal lies from award of Lok Adalat, such as Lok Adalat is a blessing for public in the field by judiciary. In legal field, it is called as social revolution. What is permanent Lok Adalat? Which cases are tried by it that highlights its constitution, powers and procedures. What are public utility services which court has jurisdiction to try to matters related to it. Let's describe in detail about its constitution as power, jurisdiction and procedure. The main aim of permanent Lok Adalat is the speedy trial of the matters related to public utility justice. Let's explain this statement. Permanent Lok Adalat is a newly concept to solve the matters related to public utility by mutual settlement. There are many subjects and matters which are related to routine life of persons like electricity, water, telephone, insurance, medical, telegraph, transportation, etc. These all are called public utility services and permanent Lok Adalat stated that started for the speedy trial of such matters. Provision of permanent Lok Adalat is provided under Section 22A to 22E of Legal Services Authority Act 1987. Public utility services. As per we have seen above, permanent lok adalat is established for the speedy trial of the matters related to public utility services. So it's important to read about public utility services. Section 22A of this Act has provision regarding public utility services. These are transport service for the carriage of passengers or goods by air, road or water. These are postal telegraph or telephone service or supply of power, light or water to the public by any establishment. System of public conservation or sanitation or services in hospital or dispensary or insurance service. Any service can be declared as public utility services by issuing notification by central government or state government. Constitution of Permanent Lok Adalat. Section 22B of Legal Services Authority Act 1987 has provision regarding the constitution of Permanent Lok Adalat. According to that, every Lok Adalat shall consist of a chairperson or two other members. Chairperson shall be a person who is or has been a district judge or additional district judge or has held judicial office higher in rank than that of a district judge. Two other persons having adequate experience in public utility services. Provided that establishing such permanent lok adalat and other terms and conditions of the appointment of the chairperson or other service conditions shall be determined by central or state authority. Jurisdiction Section 22 of this Act has provision regarding the jurisdiction of permanent lok adalat. According to that, permanent lok adalat has jurisdiction to hear all the matters related to public utility services. But permanent lok adalat shall not have jurisdiction in respect of any matter relating to an offence not compoundable under any law, where the value of the property in dispute exceeds 10 lakh rupees, provided that central government may by notification increase the limit of 10 lakh rupees specified. Matters which are mentioned in section 320 of Indian Penal Code can be solved by settlement. Solapur Municipal Corporation versus Ralikar AIR 1970, Bombay 333. In this matter, Bombay High Court decided that permanent lok adalat cannot dispose those matters which does not come in the area of 320 of Indian Penal Code 1973. Similarly, Rampal versus State of Jammu and Kashmir AIR 1999 SC 895. In this matter, Supreme Court decided that court cannot allow settlement for those matters which are not worth settlement. What is the procedure? Section 22C of Permanent Local Act has provision regarding the procedure of this. According to that, any part to a dispute may, before the dispute is brought before any court, make an application to the permanent local adalat for settlement of dispute, and after this no party shall evoke jurisdiction of any court in the same dispute. Where an application is made to permanent, where an application is made to a permanent local adalat, it shall direct each party to one is filed before it a written statement, filed before it a written statement stating there in the facts and nature of dispute under the application, points and issues in such dispute, present any evidence or proof as any document or for some other statement, and shall send a copy of such statement together with a copy of such document and other evidence. After that, permanent local adalat starts the process of conciliation between the parties. The permanent local adalat shall, during conduct of conciliation proceedings, shall assist the parties in their attempt to reach an amicable statement of the dispute in an independent and impartial manner. Both parties can present evidence in their favor. When both parties agree on a point that permanent local adalat shall pass an word, both parties shall sign the ami- amicable or settlement agreement. Where the parties fail to reach at an agreement, there the permanent local adalat shall, if the dispute does not relate to any difference, if the dispute does not relate to any offense, shall decide the dispute. According to section 22D, permanent local adalat, while conduction conciliation proceeding, one is big, guided by the principle of natural justice, two is objectivity, fair play, three is equity, four is or other principle of justice, and it shall not be bounded by the Code of Civil Procedure 1908 and the Indian Evidence Act 1872. The effect of an award. Section 22E of the Act describes that every award shall be final and binding on all the parties, shall be deemed to be degree of civil court. It shall not be called in question in any original suit, application, or execution proceeding. Civil court shall execute the order. It shall be by a majority of the persons constituting the permanent local adalat. These permanent local adalat has very much effect on social atmosphere. Now, the possibilities of speedy trial has become strong about the matters related to routine life. Critically, let's discuss the role of judiciary regarding the control of child labor in India. Indian, which was imagined by the make, which was imagined by the marks of our constitution reflects in the courageous or chivalric children. They imagine for such child who can get adequate education, protection from exploitation, and get opportunities of overall development. But the tragedy is that even after 50 years of independence, our country is stuck in the evil of child labor. Child labor is the serious problem of our nation. This thought was given by the jurist of Supreme Court, Justice Kuldeep Singh, Justice D.L. Hansaria, Justice S.V. Mazumdar in the case of M.C. Mehta versus State of Tamil Nadu area 1997 SC 699. Shivkashi at Tamil Nadu has supreme place in the field of making explosive substances. In 1985, there was around 221 registered factories of matchboxes. In these factories, 2,941 workers were child laborers out of 27,338. Shivkashi was the first city who gave employment to children in such a large ratio by ignoring the provisions of constitution. But some social service providers did not accept such violation of Article 24 of Constitution, and MC Mehta challenged it and filed public interest litigation under Article 32 in Supreme Court. The Supreme Court issued certain rules under Article 39F and Article 45. Between this, a tragic incident happened in Crackers factory of Shivkashi, where 39 people were dead. Supreme Court Sugamoto took cognizance over it by a news published in newspapers and ordered to provide compensation to the relatives of deceased and constituted a committee to make report of that incident. Members of committee DRK Zain, Indra, Jaising Kesi, thus Jaising Kesi Dua recommended following by detailed investigation. One is Tamil Nadu government must make it sure that no children should be employed in the factories which makes expensive substances. Two is in the fireworks factories, children should provide separate premises where they can fill matchsticks in frame. Three employers should not be permitted to take work from the children for more than 6 hours a day. For its proper transport facilities should be provided for traveling of the children from their homes to this workplace and back. Next is facilities for recreation, socialization and education should be provided either in the factory or close to the factory. Next is employers should make arrangements for providing basic diets for the children, and in case they fail to do so, the government may be directed to provide for basic diet. One meal a day program of state of Tamil Nadu for school children will be extended to the child workers. Next is fees, rate wages should be abolished. Any payment should be made on monthly basis. All the workers working in the industry, whether in registered factories or in unregistered factories, whether in cottage industry or on contract basis, should be brought under the insurance scheme. A welfare fund must be established and employers should be directed to deposit rupees 2 per month per worker. A national commission should be constituted for the welfare of children. Supreme Court expressed its views on Shivkashi and also said that another cities must also be protected before it becomes like Shivkashi. Right up in Indian Express of 25/10/1996 has described Bhavnagar as another Shivkashi, making as that town of about 4 lakh population has at least 13,000 children employed in 300 different industries. Not only this, uncountable children employed in various factories in various parts of country are curing their luck. Supreme Court said that it is tragic subject, accept all the views, accept all the laws, international convention. The problem of child labor has indeed spread it fang far and wide. On 20th November 1989, India accepted the convention made on the rights of children in the General Assembly of United Nations. In this convention, not only the civil rights of child was protected, but charge was took for the economic, social and cultural rise of children and protection of the human rights. Article 24 of the Constitution prohibits the employment of child below age of 14 years in factories. Article 39F says that the children are given opportunities and facility to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Article 45 provides free and compulsory education for children. In this a matter of Union Krishnan year 1993 SC 2138 is a example which says that although the Article 45 is in the chapter of directive rules but in the changing time, it has taken place of fundamental rights. Except all this, Supreme Court said that a survey should be made of apportioned type of child labor working in our country. To his children should be kept forth from instrumental process and they should be employed in the manual labor. His arrangement should be made for the competent education on the end of the employment of children. Observation should be kept on the inspector's labor department. Those persons should be punished who employs children for prohibited workers. The working hours of the child should not be more than 6 hours, and every child must have opportunity to receive education at least for 2 hours each day. These directions of Supreme Court shall not only stop the tendency of child labor, but it also for the part of overall development of children. This decision will make a child which was imagined by our constitution because it is for exception and wish. Not only this, in Mirza Chaudhary versus State of Madhya Pradesh, AR 1984 SC 1099 Supreme Court said that in today's surrounding it is not sufficient to make the release of banded laborers that their rehabilitation should also be done. Public interest litigation is the latest concept of justice. Let's discuss it. What is public interest litigation? Public interest litigation is the latest concept of justice. The startup of this concept was done due to the execution and security of rights of poor and weaker section of society. It is undisputed the most of Indian population resides in villages, which is which is a poor as well as illiterate. Also, due to poverty, they are unable to reach at the door of court for the execution their rights. This is the reason that an important part of society is derived from justice. Although in Article 39A of our Constitution has provided guarantee that no person shall be deprived from justice due to poverty. To consider all these things, the concept of public interest litigation started. It was the opinion of Justice P.M. Bhagwati of Supreme Court that new justice is not only related to well-to-do people, but the door of temple of justice is open for all. The article support Society versus Chief Justice here 1987 SC 38. In this matter, Supreme Court said that the main object of public interest litigation is to provide help to weaker section of society and providing equal opportunity of justice. Similarly, in Guru Purav Devasam Managing Committee versus C.K. Rajan, AR 2004 SC 561, in this matter, Supreme Court expressed that the object of public interest litigation is to make the process of justice easy for working for weaker section of society. It is according to the concept of human rights. The object of public interest litigation is written is neither to fulfill any political aim or to solve any political issue as per said in Kishore Bhai B. Banchal versus State of Gujarat area 2003 Gujarat 43. Justice P.B. Bhagwati said in a seminar on 18 October 1981 at Lucknow that the problem of poor is not a personal problem, that a category or a social problem. Thus, public interest litigation solves this problem. What is public interest litigation? It is difficult to give a universal definition of public interest litigation. It is concept of detailed meaning. Public interest litigation means such cases which are related to interest and rights of normal persons, like one matter related to bound labor, matter related to torture and violence in jails, matter related to torture of police, matter related to environmental pollution, matters, matters related to atrocities or scheduled caste and scheduled tribes, matter of women atrocity or violence, matters related to ignored children, matters related to person agreeing to violence, matters related to minimum wages of laborers, matters related to family pension, such as there are many more matters related to normal public which comes in the area of public interest litigation when any normal person does not bring such matters in court due to any disability, that this work is done by any organization or union. MC Mehta versus Union of India, AIR 1998, Supreme Court 1115. In this matter, Supreme Court said that the interest of public is visited, the interest of public is vested in the water of river Ganga. If its water is being polluted, then public interest litigation can be brought to save its water from getting polluted. Similarly, Nancy Mehta versus Union of India, year 1997, SC 734. Matter Supreme Court said about the protection of beauty of Taj Mahal that Taj Mahal is supreme in the wonders of the world. It is an unique example of art, Mughal art. It is an immortal piece of memory of the wife of Emperor Shah Jahan. Begum Mumtaz, an excellent piece of art of astrologist and unique combination of art and an excellent piece of art of astrologist and unique combination of art and culture. Its beauty is national heritage. To save it is the duty of every person. Degree College Society, Mumbai, Rahibasi Union, Mumbai, USA, Union of India area, 2009 NOC 2876 Bombay. In this matter, Bombay High Court said that public interest litigation can be brought to stop the sale of public property on minimum price. In short, that such kind of matters are related to public and it comes in the definition of public interest litigation. Along with this matter related to poor person who are unable to get justice can be brought by voluntary organizations of social service provider. All India Railway Victim Employee Union versus Union of India EIR 1981 SC 298. In this matter, Supreme Court said that if any person is unable to reach a door of court due to poverty, then any other person or organization can do this on the behalf. Justice Krishna Iyer stated that now the narrow thinking that only victim person goes to court that has abolished now its place as talent by class has taken by class proceedings. Public interest litigation or representative suit as Shirsha. Now any person can go to the court for the security of interest which is related to any social interest. Bandhuar Mukti Morcha versus Union of India year 1982 SC 803. In this matter, the public interest litigation was present for the workers of stone mined in the Freeport district who were subject of inhumanity and atrocity on that by Supreme Court not only those workers will be made free but directions were given to regulate the rules of labor welfare. Pratul Kumar Sinha versus Union of India year 1989 SC 1783. In this matter, order of investigation and management reform. Investigation and management was given by Supreme Court on the matter of sexual harassment of girls in blind girls schools. Rajasthan Farmer Organization versus State of Rajasthan year 1989. Rajasthan ban in this matter. Women wrote a letter to High Court related to atrocity of police. Court considered it writ and gave investigation orders. Sunil Batra versus Delhi Administration year 1980. As seen 1579 in this matter, Supreme Court directed the officers of jail to do not behave inhumanity with prisoners on the complaint of a debtor made due to inhuman behavior done in jail. Such as the concept of public interest litigation is not only limited to cases or writs, but has least near letters and cutting of news as writ and gave orders of proceedings. Vikram Dev Singh Tomar versus State of Bihar, year 1988, SC 1782. In the matter, they, in this matter, the petty condition of Nari Niketan was short to Supreme Court and Supreme Court directed to reform the conditions of Nari Niketan. Permanent Katara versus Permanent Katara versus Union Bank of India, year 1989 SC 2039. In this matter, Supreme Court, by giving the medical importance to person injured in any accident, that injured person must be provided medical facility without waiting for public investigation. By accepting the importance of public interest litigation, SP Guru Raj versus Karnataka Industrial Area Development Board, year 1988, Karnataka 223. It was said in this matter that public interest litigation cannot be dismissed on technical grounds. Prohibition. It is correct that the object of public interest litigation is to provide justice to poor section of society. Some, as it is also important to take care that it should not be misused. Our judiciary time, our judiciary time to time has issued directions in this regard. Supreme Court has decided some measures in this regard. One is anonymous letters should not be considered as public interest litigation. Many times court gets complaints through anonymous letters and they are found meaningless, by which the power and time of court was meaningless. So whatever letter is written should be written clearly with its signature and full address. Like satin, Hindustan latest companies workers versus State of Kerala EIR 1986 Kerala 193. Divine Retreat Center versus State of Kerala EIR 2008 SC 1614. In this matter, Supreme Court said that person name must be known in public interest litigation. Anonymous letters should not be considered as public interest litigation. Matters related to matters related to public interest litigation should not be inspired by politics. These matters cannot be considered as public interest litigation like the other said H.S. Chaudhary and 1982. Public interest litigation must not be related to personal interest. Matters related to personal interest cannot be considered as public interest litigation. Like Simranjal Singh versus Union of India 1992 for SCC 653. In this matter, it was decided. Whereas the question is to accept news of newspapers as read, then Ram Sarup Bagoli versus State of Rajasthan AIR 2002 Rajasthan 27. In this matter, Rajasthan High Court said that mere a newspaper of newspaper is not safe. News of newspaper is not safe on this ground because such report is to accept in evidence. SP Gupta versus Union of India AIR 1982 SC 149. In this matter, Supreme Court decided that it is important for public interest litigation that one is it should be in goodwill, two is not affected by politics, Three is not for personal interest or adverse benefit. Welfare Society of Odisha versus Union of India, AIR 20,101, Odisha 183. In this matter, it was said by Odisha High Court that public interest litigation must be accepted for the matters related to public or for wide public interest. In short, the aim is that the concept of public interest litigation meant for weaker section of society should not be misused. Let's describe in detail regarding Indian jail authorities or administration. What suggestions you would like to give to reform Indian jail authorities? Jail administration has important place in criminal law administration. It is jail administration the which execute the courts under trial and other criminals are kept in jail. The word jail is Hindi translation of Angal language. Literally, it is called in Hindi as prison, but the word jail is popular in public prison system in various countries. The system of prison is very ancient. It cannot be said that prisons were established when the judicial system came into existence. When there, when there was no court or judicial systems at that time, also prisons were there. Kans kept the Vasudev in prison, although that prison was of different type and the purpose of keeping him in prison was also different. Prison system of America, the Middle Age prison system of America was totally different from present situation. The prison system of that time was very cruel or inhuman. Basically, religious, political, or war criminals were used to captain those prisons. People who failed to pay the landed money were also kept in prison according to the time prison. According to the times prison, inhuman for inhuman tortures were used to give to criminals like to flog, to burn, in humiliate publicly, starve, hungry, etc. Public did not like this. Public did not like this system. First time in 1582 in Pennsylvania, uprising started against it. Consequently, Penn's charter was passed in 1582. It was a provision in Penn's charter that one is captives and prisoners should be given bail. Adequate compensation should be given to the person who are arrested on the basis of mistake or suspect. Proper arrangements should be made for the dwelling or food of prisons. Captives and prisoners should not be published. Captives and prisoners should not be punished publicly, etc. From here, the continuous reforms started in prison system. Quakers movement started in 1775. It was the demand of the supporters of this movement that physical torture should not be given to the captive or prisoners. Death penalty should be abolished and solitary confinement should be given at that time, at that place. The speed of the speed of reformation was gradually going on. Captives and prisoners were classified. Different punishments were decided for them. In short, the process of reformation classified can be classified. One is prisoners were divided into two parts: reformable serious or lethal prisoners. Two is reformable normal prisoner. Service of solitary confinement was made for lethal prisoners and liberal work was started taken from normal prisoners. Separate cells were made for women and habitual criminals. Remuneration was started given to prisoners for their labor. Religious preachers were appointed in prisons for reform. Human treatment was started done with captives and prisoners. Emphasis was given to establish ideal prisons. America's ideal prison system can be understood under one is Pennsylvania prison system, two is Alabama prison system, and three is Almeria reform homes. Pennsylvania prison system was in effect in the middle of 19th century. After that it was abolished. The main features of this system were captives and prisoners were kept in solitary confinement so that through silent reflection they can reform by penance. Prisoners were not allowed to meet each other. It was compulsory for the prisoners to attend teaching and lectures of religious preachers. This system failed to get its object. The result of solitary confinement was that either the poisoned died or gone mad. That was this system was abolished and Auburn system was started at that place. Auburn system started in 1888 to 1888 to 1819. The efforts were made to reform the prisoners in this system. The main features of this system was that keeping the prisoners separately according to the nature of crime. During daytime, combinedly work is taken from prisoners, but the prisoners were not allowed to talk with each other. But the prisoners were not allowed to talk each other. Prisoners were kept in separate cells during night. The reason, the reason behind keeping the prisoners separate and not allowing them to communicate with each other is to keep them away from each other so that they do not get in bad company. The text criticized this system that in spite of reformation, solitary confinement leads prisoners towards suicide. Some prisoners become insane in prisons. There was no arrangements of entertainment and sports, which is essential for the personality development of human. Millen criticized this system by saying that under this system it was tried to make discipline by suppression and labor is taken from prisoners by frightening them. An urban system seemed to fail. Then Edinburgh reform art plan was started first in 1879 in New York. Elmira Reform House was established. In this arrangement of training, parole, unfixed punished for prisoners were done. Labor was taken in industrial installations by those prisoners who were eligible to reform and some arrangements were done for their rehabilitations. Acquisition Center was established in 1933 in Alianis for criminal, where treatment remedies were used to reform the criminals, such as in prisoners, the tendency to reform the prisoners was promoted. Prison system of England. The primary prison system of England was similar to America. Cruel or inhuman treatment was done with prisoners. The prisons of that time was full of wall den, insects and pits of corruption and adultery. Facts wrote about the miserable conditions of prisoners, male, female, old, children, matures were kept together in jail. Prisoners had to do arrangements for food, etc. by their own, to used to hang their bags out from the windows of prisons for food. In short, their condition was miserable. In the end of 18th century, arrangements of religious preachers was done in prisons and labor was started taken from prisoners to end the boredom of solitary confinement. For more reformation, an act was passed in 1118 by British Parliament. Emphasis was given on rehabilitation to end the guilt and monotony. Gladstone Committee was constituted for prison reform after the recommendations of this committee in 1898. A Prison Act was passed. The credit of real and effective reformation in England prisoner system goes to Sir Lionel Fax. He is called the father of a reform or prison system. Sir Lionel Fax suggested many ideas of prison reform. The main suggestions are following: the officer in charge of prison must well inform the public regarding reformation to satisfy them. Time to time, public representatives should be invited in prison so that no misconception can arise in their mind. The annual reports of prisons must be published, establish coordination between the various theories of punishment. Punishment must not be hard but certain. These suggestions were applied after passing the Criminal Justice Act 1948. Portals were opened, hostage system was started for prisoners, flexibility was given to the rule of parole. Gradually, the prison system of England became ideal. The present prison system of England depends upon the informative and preventive principal purpose, arrangements of food, shelter, education, medical and entertainment is available in the prisons at present. Indian prison system. The prison system of India is very ancient. Prison system is described under many Dharmshastras. Manu, Brihspati, Kautilya has written many things about the ancient prison system. Brihspati was supporter of closed prisons where the Manu had opposite views. Kautilya suggested in economics that prison must be made at the sites of roads so that prisons can watch the outsiders to remove their solidarity. The punishment system of Mughal and Mohammedan time was hard. The prisoners was given death penalty, deprivation of body parts, beating, to burn, etc. Punishment. Sometimes criminals were fixed in their world. The system was not static due to being very cruel. Minor changements